Hello, and thank you for joining us for the Business Operations Educational Conference as part of the 2021 virtual Southeast Regional Fruit and Vegetable Conference. I'm Chris Butts, Public Affairs Director with the Georgia Fruit and Vegetable Growers Association, and I'll be your moderator today. Today's presentation is a live presentation. At the end of the presentation, we'll be answering your questions live. You can submit a question at any time during the presentation by typing your question into the questions box and pressing send. We ask that you do remember to thank our 2021 conference sponsors and exhibitors by visiting the virtual trade show and featured products pavilion on the platform. And lastly, don't forget to join us each morning for our coffee chats and evenings for our evening networking sessions. You can click on the conference agenda on the platform for more details. Today, I'd like to introduce Josh Viau with Fisher Phillips, who will be presenting on federal labor regulations affecting farm employees. Josh counsels and defends many ag employees in connection with the Fair Labor Standards Act and the Migrant and Seasonal Agricultural Worker Protection Act, the H-2A Temporary Foreign Ag Worker Program, and other federal and state employment and discrimination laws. His work for employer clients includes defending claims and advising employers on day-to-day issues arising under state and federal statutes. Josh works with a variety of national and local clients, including employers in agriculture. He's been selected to the Best Lawyers in America since 2015 and was recognized as a Georgia Super Lawyer since 2015. He's a familiar face for many of our folks. We're glad he's with us today. And with that, I will turn it over to you, Josh.
Well, thank you, Chris, for that introduction, and thank you all for having me. I do appreciate it. I do wish that we were in person, but we will do what we can given the current circumstances. Getting rather adept at dealing with the platforms that require us to meet virtually like this. The title of this presentation today, Federal Regulations Affecting Farm Employers, quite frankly, could be the title for a 3-day long seminar. We could cover all of the time that we've got this week for this topic. And so I say that to give you all the caveat that we're going to touch on at a surface level of many of the employment law issues that you all have to deal with in agriculture, and there are several issues that you all have to deal with that we will not touch on at all, just given the nature of the time frame that we have. But what I've tried to do is compile some kind of hot topics and issues that agricultural employers are dealing with based on the calls that we're getting. And as you all probably, hopefully will see, these are some of the issues that you all are dealing with, and if you haven't dealt with them, you probably will deal with them. So to kind of grab your attention, I wanted to talk about a little bit about the importance of employment law compliance and why you should be especially vigilant regarding your compliance with these issues. And there's two that I have listed on this slide. And the first is that the reputations of farmers and the agricultural industry are under attack and have been, unfortunately, for some time. There are groups out there and there are folks in the media who, for whatever reason, view farmers as the bad guys, and especially when it comes to employee relations. And I think that stems from some ancient history in the industry, and also that a few bad apples tend to grab the headlines. What I've found in the 6 or 7 years that I've been working with agricultural employers, more so than prior in my career, is that everybody, 99.9% of us out there strive to do the right thing. The unfortunate thing is that some folks don't, and also that our industry is so heavily regulated that even the best efforts at compliance are going to leave some gaps. And so it's really important for us to be as vigilant as we can to protect the reputation of our industry. And the second is always follow the money. The government and farm worker advocates want your money, and if they can find industries that are so heavily regulated that it makes it difficult for folks to comply, then that's low-hanging fruit for them, because odds are if they start digging, they're going to find they're going to be able to find some issues on which they can ding you for. I just put in some recent headlines, and these are not as recent as they once were when I probably came up with them, but the tenor of these articles has not changed, and you can see that some of the verbiage used in these headlines is frankly insulting to those of us in the industry and those of us who provide services to those of us, to those of you in the industry. In addition to media, we also have to look out for these guys who you see on TV, especially on the wage and hour front. A lot of these plaintiffs' firms, even those that focus on typically on personal injury type situation, the folks that we typically think of as being ambulance chasers, for lack of a better term, realize that there's money to be made in wage and hour, which is a big issue, of course, in agriculture. And the unique aspect of the Federal Labor Standards Act is that it provides for attorney's fees for attorneys representing aggrieved individuals. And so, you may have a case where your violation is minimal, but the attorney's fees can turn out in those cases to be even larger than the award itself. And so that has caused some folks on the plaintiff side of the bar to become more interested in wage and hour cases, and as a result of that in agriculture than perhaps they were before. And then, of course, you have the farm worker advocacy groups, who are what we, of course, refer to as the true believers. And they are consistently looking for individuals to represent. They are funded by either government and private donations, and so they are looking for publicity to show folks that they are doing the good work of protecting farm workers from big bad employers who want to take advantage. And then, as if the plaintiffs' lawyers and the farm worker advocates were not enough, you also have the government agencies that we have to deal with. You have the Department of Labor, which of course enforces the Fair Labor Standards Act, and also the H-2A program. You've got Homeland Security and ICE governing immigration. And so we're really in agriculture being attacked on several fronts. And so that's why it's important for us to be vigilant about compliance and handling situations in the right way. Before we get into the meat of the regulations and the laws that we're going to talk about, I always try and give a little bit of a soapbox speech at the beginning of this and say, I'm going to be throwing a lot of alphabet soup at you today. We're going to be talking about FLSA and MSPA and H-2A and Title VII and all these other laws. But a general rule of thumb in employment law is to treat people fairly. Most of the cases that we see and the claims that we see really result from misunderstandings or from situations where you have workers who are surprised by something that happens to them. So if we are diligent and with our communication and with engaging in progressive discipline when there are performance issues and things of that nature, and we treat people fairly, that will go a long way towards minimizing the chances that you're going to find yourself on the wrong end of a lawsuit and potentially a government audit. Now, you may do everything right and still be subject to a government audit, although the government agencies will audit you based on a complaint from a current or former worker. They also may audit you without a formal complaint. And it may be something as simple as you have a federal wage and hour investigator who happens to be driving by your farm on the way to somebody else's farm and decides they're going to stop and check things out on your farm. So it doesn't get you complete immunity, but it can go a long way in terms of adhering to the golden rule when it comes to our employees. Now, I also say that with a caveat of another saying I have in employment law is that it's the one area where no good deed goes unpunished. Because sometimes when you're trying to do the right thing or trying to help somebody out, you can put yourself in a position where you're vulnerable. And we'll talk about that when we get into some of the detail about some of the specific issues that we're talking about today. But I always like to just kind of give that general kind of overriding framework in terms of what we're talking about in terms of treating people fairly and consistently and making sure that you're communicating with your workers so that everybody has an understanding of what the expectations are and what the consequences are for not meeting those expectations. So let's talk about first about discrimination and harassment. And this is the, I call these the old guard of employment law. This is what's the laws that have been around for a long time and we've had to work on compliance with for the last several decades. Where we see a lot of issues coming up more consistently in agriculture is with the Americans with Disabilities Act, and that involves discrimination and accommodation, and then of course the civil rights laws, and specifically with respect to harassment. And I'm sure we've all heard the term hostile work environment, which is a term that gets misused most often by our employees themselves, which we'll talk about. And then you've got things like age discrimination and then discrimination based on race, color, religion, sex, and national origin. So let's talk first about the Americans with Disabilities Act. This covers all employers with 15 or more employees. It prohibits discrimination in employment on the basis of a disability. And disability has a very broad definition. It had a broad definition before, and then several years ago, they amended the act to make it even a broader definition. But generally, it's a physical or mental impairment that substantially limits a major life activity. Major life activity being walking, standing, driving, working. To be covered, a person also has to be qualified to perform the essential functions or duty of the job with or without a reasonable accommodation. You can see how why us employment lawyers have job security, given the number of phrases in that definition that can be subject to interpretation. And there are several interpretations that go along with those. But assuming for our purposes that an employee is covered, then an employer is obligated to provide a reasonable accommodation for that employee. You can't just simply say you can't perform the job, so you're fired. You've got to engage in what's called the interactive process when an applicant or an employee requests a reasonable accommodation for a condition. And so let's talk about requests for an accommodation. So this can be a scenario where, for example, somebody comes to you and says that you've got an employee or an applicant who says, I've gone to my doctor, I've injured my back, and I've got this doctor's note that says I can't lift more than 15 pounds. And so that you've received, that's enough to trigger your obligation to engage in this interactive process when it comes to an accommodation. The employee does not have to specifically say, I am requesting accommodation. The accommodation does not have to be in writing. In fact, the accommodation doesn't even have to be made verbally. You either know or have a reason to know that this employee could need an accommodation. So no formalities are required. It also can come from someone else besides the employee themselves. So it's a situation where once you have knowledge, you have the knowledge, and you can't rely on some kind of formality to refuse the obligation to engage in this interactive process. An important point on that also is that your managers and supervisors, as representatives of the company, they need to be educated on this because they are also the eyes and ears of the company. And so if they know or have reason to believe that somebody may be in need of an accommodation, For example, if there's a performance issue, but somebody's having trouble meeting the production requirements because of some physical limitation, if the supervisor's on notice of that, then you are on notice of that. So once there's a request for an accommodation, you have to engage in what can best be described as a case-by-case type inquiry and interactive process to determine whether accommodations are appropriate, needed, and available. So as I mentioned earlier, you don't want to just say, I can't provide an accommodation, you're out. You want to make sure that you refer to an HR person if your organization has one of those. If you work with a PEO, some of them have resources. And then, of course, lawyers are always a good resource in terms of dealing with these issues as well. When dealing with these accommodations, also, you want to make sure that you're protecting the confidentiality. We're not necessarily invoking HIPAA in every accommodation request, but we do have an obligation to protect personal health information of individuals. And so you also want to ensure that an employee who receives an accommodation is not mistreated. So for example, if I have requested and been granted some kind of an accommodation that other workers are going to perceive as making my job easier than theirs, there may be some hard feelings and some retaliation and things like that from coworkers or even from supervisors or managers. So we want to make sure that that's not the case. Now, the question you're probably asking yourself is, okay, well, do I have to give in and just give this employee whatever accommodation they request? No. What the law requires is that you provide an employee with a reasonable accommodation. And interactive process just basically means you have a conversation with the employee. They may have an idea about something that may work as an accommodation. You may have an idea about something that may work as an accommodation. But the accommodation has to be reasonable, meaning it can't be overly disruptive to your operations. It can't be too expensive. Cost is a factor that courts and the EEOC will look at. And it also, you're not required to materially change the job duties. The employee still has to be able to perform the essential functions of that job. The kind of simplistic example that I usually use is I've mentioned the 15-pound lifting restriction. So if I come to you and say, I can't lift more than 15 pounds, and what I would propose is that whenever I have to lift 15 pounds, Chris, who works next to me, he can lift that 15 pounds for me. Well, if I'm lifting 15 pounds 3 times a day, that might be doable, and that might allow both Chris and I to continue to perform the essential functions of our job without too much interference. If I'm lifting 15 pounds 5 times an hour, asking another employee to do that is essentially pulling them away from their job, and that would most likely be deemed unreasonable. And so you have to kind of go back and forth and try and determine whether there is a reasonable accommodation that would allow the employee to perform the essential functions of the job. So that's a very quick kind of overview of the ADA and how to deal with accommodation requests that you might receive. If we're doing a 3-day seminar on just the federal employment laws that you need to deal with in agriculture, the ADA itself is going to be 1 to 2 hours of that. And so, as I mentioned, we're really doing an overview here, and I'm going to try and avoid getting too deep into the weeds, especially on these ADA accommodation requests. It's one of the more complicated things that employers have to deal with when it comes to dealing with the discrimination laws. So let's talk about the other old guard of employment laws, Title VII, and this is kind of the one that everybody knows about. Everybody knows about the EEOC that enforces Title VII. Title VII is the statute that prohibits discrimination because of race, color, national origin, religion, sex, pregnancy, et cetera. It applies to employers engaged in interstate commerce that have at least 15 employees. And the employee or an EEO or the EEOC, which is the federal administrative agency that is tasked with enforcing Title VII, can sue for back wages, reinstatement, promotion, attorney's fees. For quote unquote intentional discrimination, employees can also get compensatory damages and capped punitive damages. It allows for a jury trial. It allows for class action relief in cases of systemic or widespread discrimination. The main thing that you need to look out for in terms of discrimination cases are what we call disparate treatment cases, and that's treating people differently based on a protected class. And this is where sometimes the no good deed goes unpunished saying comes into play, because you'll have an employee who's a long-term employee who has been with you for a long time. They're a member of the family. They've always done a good job. And you may make an exception for them. You know, they may engage in some misconduct, and you say, okay, well, you know, we're going to just give you a warning this time just because of your work record and our relationship with you. And let's say that person is from Mexico. And then you've got a brand new employee who you're not really sure about. You know, they're kind of, you're not really sure if they're going to make it. Their performance isn't all that good. And they engage in the same kind of misconduct. And that's a domestic worker. And so you say, well, I'm firing you for that because, you know, that's a terminable offense. Well, even though you had a good reason for making the exception in the first case, those folks are going to be comparators, and they're going to be compared to each other. And so while certainly there are legitimate reasons for treating folks differently, that's the threshold determination in one of these discrimination cases. One of the threshold determinations is whether the employee can identify somebody outside of their protected class who's similarly situated, who was treated more favorably. And so this employee that you fire is immediately going to go to a lawyer or an advocate and say, I got fired for this. And, you know, Josh, he did the same thing 2 weeks earlier, and they just gave him a slap on the wrist. And I think it's because, you know, he's of Mexican descent, and I'm from the United States. So I'm being discriminated against on the basis of my national origin or something of, you know, any similar differences. So let's talk next about the Age Discrimination in Employment Act. The same concepts apply in the ADEA context. You can see what the summary of the coverage here is, that you have to have at least 20 employees. Prohibits age discrimination in employment. It covers employees 40 years of age or over. The penalties are similar. The employees or the EEOC can sue for damages or back wages. They get the right to a jury trial. They can sue for attorney's fees, double damages if a violation is willful. And again, like Title VII, class action relief is available under the ADEA. So let's talk about hostile work environment. And this is a term I mentioned early on in the presentation. You know, we all have heard the term hostile work environment thrown around by employees or relatives. It's really, you know, it has a legal meaning, which is what we're going to talk about. And then it has a general meaning among society that really has been expanded to include anything I don't like that happens to me at work. If my supervisor's treating me in a way that I don't like, or if I didn't get a raise that I thought I deserved, or if I got transferred to a job that I don't like, or if the temperature in my office is too high, well, I've been subjected to a hostile work environment. And so we hear that term a lot more often than it's actually applicable from a legal perspective. And so let's talk a little bit about the hostile work environment, the legal definition. And so it's got to be based on a protected characteristic. That's really the first thing, is that, you know, a hostile work environment, to be actionable, you have to be being harassed or treated badly because of your race, your gender, your national origin, your age, some kind of protected characteristic that is the basis for that mistreatment. The other thing is that it doesn't protect folks against what the case law calls normal trials and tribulations of a workplace, which is subjective to some point. The standard is going to be a little bit different in a manufacturing environment than in a school or a library, for example, but it's got to be objectively severe and pervasive. It means it's got to be bad and it's got to be ongoing. Even a very severe offensive single comment is likely not going to be enough to support a claim for a hostile work environment. It's got to create a work environment such that a reasonable person would find hostile or abusive. They're often difficult to recognize because it is based on the particular facts of each case, and it can also be based on the case law in the jurisdiction you're in. The 11th Circuit, which is where we are here in the Southeast and in Georgia, has traditionally been a very employer-friendly jurisdiction on a federal court level. That's changing a little bit with some of the appointments that came under the Obama administration. It's not quite as employer-friendly as it used to be. But there are some cases out there that talk about hostile work environment that even as a guy with thick skin and a lifelong employer advocate, I look at some of the cases that say this is not enough to support a hostile work environment, and I say that looks pretty severe and pervasive to me. So the standard is pretty high, and what I always advise my clients is, we don't want to do just enough to comply with what legally constitutes a hostile work environment. We want to go above and beyond that. We want to make sure that our employees are not, being subjected to anything that's discriminatory or harassing on even a lower level than what's required under the law. So as far as the employment litigation trends go in agriculture, U.S. workers are filing race discrimination claims based on race and national origin in terms of favoring Hispanic and foreign workers. We'll talk a little later about the H-2A program. As those of you who participate in that program know, that's especially important in terms of discrimination under the H-2A regulations. Favoring foreign workers over domestic workers can get you into some serious financial trouble with the Department of Labor. Harassment based on sex and national origin, and this isn't just domestic folks discriminating against or harassing foreigners, or we've seen cases where there's harassment where a certain group of foreign workers from one part of the world are harassing a group of workers from another part of the world, or the workers from Guatemala are getting better fields and being paid higher piece rate because of that than the workers from Mexico, and things of that nature. Keep in mind that these claims also always include a claim for retaliation, meaning that once an employee makes a complaint, they can't be retaliated against for making that complaint. And sometimes employees will do things to get themselves a little protection. If they see the writing on the wall, there's been performance issues, attendance issues, something like that, an employee says, well, they think, all right, well, I'm about to be let go. All of that, all those jokes and everything that I've been putting up with for the last 6 months, well, they're not actually funny to me, so I'm going to file a complaint. And so then you've got an added layer of issues to deal with in terms of making sure that employee doesn't get retaliated against. And then, of course, the ADA accommodation issues, mostly because those are just so difficult to deal with and have to be dealt with on a case-by-case basis. So I've got a little scenario here just to kind of highlight some of this information. It's a little bit more effective when we're face-to-face in a room and I can kind of call on people and pick on people. But I want you all to meet Joe. And Joe is a packing house supervisor who started as a field laborer, and he's been working on the farm for 5 years. You think he's of Hispanic origin, but you don't know where he is originally from, or you don't know his exact nationality. Now, Joe's wife also works on the farm. She's the only female employee on the farm, which, as you all know, is not uncommon. A few months ago, she complained that male employees were making inappropriate comments to her. You did the right thing. You investigate it. The employees denied it, so you did nothing further. Joe complained after that. He thought your investigation was ineffective. A few weeks later, you moved him back to the field supervisor to replace an employee who quit. Joe's performance has fallen off in the last few months. He seemed to develop a poor attitude. He's been late without calling. He always has an excuse like his mother's sick, traffic, etc. But we've not given him a formal write-up. One day you're checking Facebook and you see pictures of Joe at a farm worker justice rally with the comment, "Enough is enough, time to fight for our rights." Two of Joe's coworkers liked the picture. You've had enough. The next day you terminate Joe for excessive absenteeism tardiness. The next day, Joe's wife resigns, saying she doesn't feel safe at work without her husband there to protect her against her harassers. Is that the end of the story? Of course not. And so let's talk about, what does Joe do? Joe may be embarrassed by the termination. He has no money. He has no prospects. He's been at a farm worker justice rally, so you know that he can also now become a martyr for the cause. So Joe is likely going to go talk to the folks at Farm Worker Justice and tell them everything that's gone on over the last year. So what are Joe's potential claims? What are Joe's wife's potential claims? So wrongful termination. Does Joe have a disability claim? Probably not. Didn't seem to be anything in that factual scenario that would warrant him being disabled. Now, let's say instead of saying his mother was sick, which comes in under the FMLA, let's say Joe had an injury and had been late or missing work due to doctor's appointments. He might have a disability claim based on that. What about race or national origin? Well, that probably comes down to how we've treated other individuals with similar attendance problems. FMLA, which is the Family and Medical Leave Act. We didn't talk about that specifically, but that provides leave to employees, and you're only covered under the FMLA if you have 50 or more employees. But that entitles employees for leave not just to deal with their own medical issues, but also to deal with medical issues of family members. So Joe saying, "Oh, I've had to take care of my sick mother," may trigger an obligation to you to provide him with leave under the FMLA. What about retaliation? Well, Joe did complain that his wife had been discriminated, or his wife had filed a complaint, and then Joe complained that he didn't think your investigation was effective. So certainly if he files something against you, it's going to include a retaliation claim. Gender, again, depending on how you've treated female employees in similar situations. Now let's talk about First Amendment / invasion of privacy as well. This is something folks are always say, "Oh, well, I've got a First Amendment right to say, whatever I want." Well, first of all, the First Amendment only covers government actors. And so there's really no First Amendment right at work. If you are covered by the National Labor Relations Act, which most farm workers are not, you don't have the ability, you do not have protection of the National Labor Relations Act, which protects your right to basically complain about your working conditions and to engage in concerted protected activity, which is basically, it's one, trying to unionize, but also it's organizing as a group to complain about work. And that law has been expanded to cover things such as Facebook posts. What about invasion of privacy? That really comes down to what you had to do to get access to Joe's Facebook page. If what you saw was a public comment and he had done nothing to protect his account, then he doesn't have a reasonable expectation of privacy in those public comments that he made. Now, if you engaged in some kind of secret, clandestine manner of getting access to his privacy protected account, maybe got his password, something like that, then you're getting into where Joe had a reasonable expectation of privacy in that content, and you took actions to violate that privacy. And so you could have a potential invasion of privacy claim in that scenario too. So I talked about that on that slide, the social media aspects of Joe's. So what about his wrongful termination claim? And you say, well, but my farm's in Georgia, and Georgia is an at will state. And my relatives always ask me, well, what do you do in Georgia as an employment lawyer? It's an at will state and a right to work state. Well, my response is that Georgia is an at will state, but the United States is not an at will country. And that's all of these laws that we've talked about are federal laws. And now a lot of states, fortunately, not Georgia yet, also have their own discrimination statutes, but Georgia does not. But that's where these claims will be brought, are under those federal laws. So if you're Joe, or worse yet, Joe's attorney, what things do you start looking for to build your case? Well, we talked about the comparator situation. They're going to start looking for other folks who had similar attendance issues or other similar performance issues who were treated more favorably than Joe. They're going to look for other employees who maybe have made complaints similar to what Joe's wife made and see how they were treated. So if you're the farm, what things do you want to do to start to build your defense? You want to preserve all the documentation. We're going to want to make sure that we've got our ducks in a row in terms of being able to distinguish any other disciplinary actions that have been taken or not taken. You're going to want to, unfortunately, the self-serving portion of the presentation, you're going to want to get in touch with your lawyer and make sure that you put yourself in a position to defend against these claims, because the more we have to rely on our word versus their word, the less chance we have of success, and the more expensive it gets, because you've got to get further down the road to resolve those factual differences. This is the call that we always get is, I've got this employee, he's been a really bad performer for a long time. We're ready to let him go. We just, Josh, wanted to call and run it by you, of course, just to make sure there's, we're not at any risk here. And of course, the first question out of my mind is, well, what documentation do you have? Well, we don't really have a lot of documentation, but we've talked to him about these issues, and so he's not going to be surprised by this. Okay, well, that's not ideal. Well, how many times have you talked to him? Well, we talked to him about 18 months ago about this, and well, it's not looking too good, because Joe's going to be surprised when you come in and tell him about this. And they say, oh, and by the way, Joe complained about, his wife's sexual harassment complaint a couple of months ago, and he had these social media. So that's why we want to make sure that we, including our managers and our supervisors, are engaging in communication and progressive discipline at every step along the way. And it's difficult because these are not the easy conversations to have. But if we have, the ideal case is where we let somebody go and we've got all of the documentation in place. We've had discussions with these folks. We've got notes. We've got detailed attendance records, etc. Those are the easier cases to defend. So what about the stated termination reason that we're terminating Joe for attendance? Is that going to cause any problems? As I just described, it likely will, because we haven't written him up for attendance. From our scenario, he was only late just a few times. So was Joe terminated for excessive absenteeism? It doesn't look so hot. Do we have documentation? Probably not. And as I mentioned, how were other employees treated with similar performance and misconduct issues? I mentioned the FMLA, like the discrimination statutes, some cases are also implementing leave laws that have more coverage. So if you're in a state that has those laws, make sure that you're up to date on those as well. So how to avoid a lawsuit? What actions should you take? I've been kind of peppering these in throughout the presentation, and it's really about two things: consistency and communication. If you engage in those two things, well, I got to add a third too, of course, documentation. We're always big on documentation. And so if you have those three things in place, you'll likely be in a better position to be able to to defend against, and actually, you know, the ultimate goal is to avoid a lawsuit. You put yourself in a better position to avoid a lawsuit and in a better position to defend yourself should you unfortunately get sued. So as mentioned, you want to document misconduct and poor performance. When in doubt about what the appropriate disciplinary action is, suspend and investigate. Sometimes employers get in trouble because they feel like they have to do something right away, and they feel under the gun, and okay, well then, you know, we're just going to terminate. And you know, often your first instinct is correct, but not all the time. And so sometimes it's good to just say, okay, you know what, we're going to give you we're going to suspend you while we investigate this, and we're going to get back to you, and then you can kind of take a step back, look at the information you have, look at what additional information you might need, and make sure that you've got your ducks in a row before you take the action. Of course, you want to treat the employee with respect when terminating him or her. You know, it's not an easy thing for anybody when somebody gets separated, and so the way that meeting goes can often go a long way towards determining whether the employee is going to be likely to file a lawsuit or go talk to somebody at a government agency once they're gone. You want to consider whether to contest unemployment claims. Sometimes that can be a tipping point for employees. You know, if you can test the unemployment claim, then that can, if they were considering whether to file something or not, they will. If you know, it can push them over the edge, so to speak, if you fight their unemployment claim. You want to make sure you, of course, engage in management training. As I mentioned, your managers and supervisors are the frontline defense against these claims. And then you also want to consider severance agreements. And basically what this is it's an agreement that you get an employee to sign when they leave, and it says, hey, we're going to give you 3 weeks pay, 4 weeks pay, whatever it might be, in exchange for you signing this release in which you agree basically not to sue us. Now, sometimes we have clients who will give employees severance without getting a release agreement, and there's nothing more painful than paying off an employee, not getting the agreement, and then having them come back to try and sue you for even more money. So, if you're going to present, some severance to them at the end, you want to make sure you get that separation and release agreement. And we have templates for severance and release agreements that we use that vary based on the situation. You know, some of them are 12 pages long and make sure that every avenue is covered, and others are somewhat simpler agreements to make sure that we have the basic protections in place. So you need contingency plans for HR issues. You want to anticipate what those issues are going to be. You want to have your initial response planned ahead of time. You want to educate your first responders. You want to identify who your advisors and experts are, whether those are your attorneys, your PEOs, your labor providers, et cetera. And you want to try and successfully resolve issues on the front end so that way you can minimize or avoid legal liability. All right, so moving on from kind of the discrimination and retaliation issues, what about the labor shortage? I mentioned the H-2A program, and you know, normally I do a show of hands, how many participate in the H-2A program, and it's going up every year. Basically, it permits the employment of temporary foreign workers in temporary or seasonal jobs that are within the definition of agricultural, pressing apples for cider on a farm, and logging under IRS and FLSA regulations. And you know, the regulations are constantly, there's proposals to change the regulations. They are what they are now. The requirements are onerous. People do comply and manage the unique benefit. Wages are generally higher than what's required in terms of minimum wage and applicable state law requirements. You've got to deal, you've got to pay employees the AWR, and there are revisions to the AWR pending that are currently enjoined from going into play. It's what's AWR stands for, the adverse effect wage rate. The idea is that The government doesn't want these temporary foreign workers being hired at wages that will have a negative impact on the wages of domestic workers. If you participate in the H-2A program, you're also agreeing to comply with all applicable laws, federal and state, and regulations. And so in addition to getting claims under those specific laws, if you participate in the H-2A program, you're also going to get a breach of contract claim because you're making a contractual commitment in your H-2A agreement to comply with those laws. So as I mentioned, the H-2A approval process and the regulations governing H-2A workers are somewhat onerous. You have to complete a Form 790 job order and submit it to your state SWA, State Workforce Agency. Then once it gets approved, you submit that with a 9142A form to USCIS for approval. That form must include all terms, conditions of employment, and they must be bona fide. They've got to be consistent with those applied by other farms in your locale and industry. That includes any production standards that you include in there. So, if you're going to have production standards that you're going to require H-2A workers to meet or corresponding U.S. workers to complete, they can't be, they're going to look at those and say, okay, are these in line with industry standards? And the applications are public, so you can look up and see what your contemporaries are requiring, or you can talk with others in the industry to see what they're requiring. Before you submit this, you have to demonstrate that you've made efforts to recruit domestic workers, and that no domestic workers are available to perform the work under the job order. And in addition to that, I mentioned corresponding U.S. workers. And so if you have domestic employees who are performing the same job duties as the H-2A workers, they are also subject to all of the protections of the H-2A program, which includes providing transportation, housing, et cetera. And so they are basically subject to the H-2A job order as well. I mentioned earlier in one of my examples about treating foreign workers more favorably than domestic workers. And it's basically the reason the program is as onerous as it is because the idea is that the government does not want us utilizing temporary foreign labor where domestic workers can do the work. And they don't want us discriminating against domestic workers in favor of foreign workers. And so you have to make sure that rules, production standards, et cetera, that are being enforced for domestic workers are also being enforced for foreign workers. The fines are, I think, approaching, if not now exceeding $17,000 in civil money penalties per violation when it comes to discrimination in favor of foreign workers. And so I cannot emphasize that enough to make sure that we're being consistent in that regard. Other important H-2A concepts is make sure that you keep records of everything, backup computers for at least 5 years. I mentioned corresponding employment, and it's important to remember that U.S. workers who perform work within the job description or any work the H-2A workers are doing shouldn't do but perform must receive the job order, contract, and all employment benefits under that H-2A job order. You cannot lend your H-2A workers to someone else unless you're part of an H-2A joint employer association. You have to reimburse costs associated with travel and expenses to get to the job. Maintenance of housing remains the employer's responsibility. So you have to make sure that the housing and what we advise is that you have an inspection list. And that you inspect the housing once a week to make sure that you're in compliance with all of the OSHA and MISPA requirements that a wage and hour Department of Labor wage and hour investigator is going to look at if they come out and inspect your housing for the H-2A workers. Be careful what you say, and this gets down to another issue that is hot right now, and especially for the farm worker justice advocates, is human trafficking. And so you do not want to say or do anything that could be viewed as a direct or implied threat that would affect a foreign worker's ability to stay in the country. You want to protect their ability to take lawful actions for lawful reasons. And you want to give your operation the ability to do that by making sure that you include that in the forms, work rules and things like that. On the job and hiring, make sure you don't give anybody a reason to believe that they're being discriminated against. Consider criminal conviction issues related to the job, living environment, accommodations to permit someone to do the job, etc. And so in terms of human trafficking, it's important to not do things like limit the employee's ability to move in and out of the housing, for example, when off duty. It's important to do things like not maintain their visas, because that's going to be viewed as limiting their ability to move freely while they're in this country. And it's a little bit counterintuitive because they're here to work, so we want them working. So, or, you know, often we'll say, well, we're only holding on to their visas for safekeeping, for their benefit. And we understand all that, but a farm worker justice advocate or a court is going to look at that, and the employee ultimately come back and say, well, you know, I couldn't go anywhere because my employer had my visa, and so I felt limited, and that can lead to you know, human trafficking type charges, which we're seeing allegations of more regularly in demand letters and in lawsuits that are being filed by the farm worker advocacy groups. Make sure you may want to consider a third-party complaint mechanism, whether that be like a 1-800 number, or, you know, someone on your farm who's designated to receive complaints about wages, harassment, virtually anything that may be considered could create a problem for you. And some more things to think about. This is along the same lines in terms of the human trafficking type issues. You can't want to make sure nobody's paying any kickbacks. If you're using recruiters in Mexico or some other country to get workers, you want to make sure they're not getting fees or kickbacks. You have to contractually forbid foreign agents from doing so. You want to make sure the H-2A workers understand their obligation to leave at the end. And you want to make sure that all of your posters are up. Additional considerations, expect to be investigated for compliance. Especially if you participate in the H-2A program, odds are that if you are going to be subject to a Department of Labor investigation every 2 years, if not more. And for that reason, you also want to keep meticulous records on referrals, applicants, why people are fired, keep pay records, keep very detailed and accurate on-the-spot field records, and make sure that those line up with the pay records. That's where we run into a lot of problems is, you know, we'll have employees come in and say, no, we were working 12 hours a day. And, you know, then we get field records that just have, you know, 8, 8, 8, 8, 8. Well, that, you know, you can look at that and tell that somebody's not out there really keeping real time of how much the employees are working on a day-to-day basis. So we want to make sure that we're keeping and maintaining those field records. I'm going to look through things a little bit more quickly now because I'm coming to the end of my time. I promised Chris that I'd give some time at the end for questions. But I also give him the caveat that I fit the stereotype of my profession, that I will likely talk longer than I had anticipated. Another thing you have to look for is the Migrant Seasonal Worker Protection Act, which provides protections for not necessarily foreign workers under the H-2A program, but it applies to migrant agricultural workers and domestic workers in corresponding employment. There are documentation requirements and housing and transportation requirements that are different than those under the H-2A program. MISPA makes it also has requirements in terms of maintaining payroll records. If you're using a staffing company or a payroll company, they don't always get it right. So you want to make sure that that you're getting those records and make sure that they're being maintained accurately. The sample worker pay and hours form is not in the written materials, but I can get one to you if you'd like one. That's just left in there from another presentation. So that's it in terms of what I have for you. I don't know if there are any questions. I don't see any questions in the question box or in the audience chat. So with that, Chris, I will turn it back over to you, and maybe everybody just gets a 5-minute break if there's no questions.
Okay. Well, Josh, I've got one for you, and thank you. I mean, it's, as always, a super informative presentation. I'm back to being Joe Farmer, and I've got a problem either with Department of Labor or, whatever authority. How do I know when it's the time that that's gone beyond my control and I need to pick up the phone and call Fisher Phillips and say, I need help?
Well, this is another self-serving response, but my preference is as soon as the Department of Labor shows up. That's when it's easiest for us to deal with it. But I will say this: the Department of Labor is going to show up. The investigator is going to flash a badge. They're going to say, "I'm with the United States Department of Labor, a federal government agency that enforces wage and hour laws and other laws, and I need to see all of your pay records, all of your personnel files, et cetera, et cetera, et cetera, and I need to see them now." And they do not have a right to see them immediately. But investigators will try and strong arm you into giving them everything right there. You've got 72 hours to provide that information. Ultimately, if we get involved at that stage, we don't turn everything over. Sometimes we will not get a call until after the Department of Labor has issued its findings, telling the farmer how much you owe and why you owe it, and it's more difficult to defend at that stage. So our preference is earlier the better. It's going to put us in a much better position to be able to defend and to be able to put the farm in a position to survive the audit, with minimal adverse findings.
Okay. Very good. Well, we are coming up on that 4:30 deadline, so we might let everybody have a break. So I'd just like to thank Josh for a great presentation. I'd like to thank all of our attendees for being with us. A couple of reminders: if you are trying to do CEU credit, remember to sign out on the audience chat. And also, I think very importantly, all of these education sessions will be available on demand starting Monday. So a lot of information covered in this one. So if you want to come back and check it out, you can, and they will be available until April 30th. So with that, again, thank you for attending. This will conclude the event, and we'll see you at the next one. Thank you.